Welcome to Solving Citizen Legal Encounters. All right, today I'm bringing the video back to you because our Solving Citizen candidate had his last hearing. Okay, so there's two hearings on this video. The first one that I originally did for people that may be coming through that haven't seen it, and then the second one is right after that. I'll itemize them in the timeline so you know which hearing is which. Okay, so we're gonna go on in. The first one's pre-recorded. Just check it out so you know what's going on, and then we'll go to the second one. Okay, all right, let's go.
All right, Brian Taylor, please. All right, this is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. Are you Brian Keith Taylor appearing there from the jail?
Yes, sir. Yes, Your Honor.
All right.
Okay.
Just a minute. Be quiet. This is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. This is a pretrial being conducted by Zoom. The defendant's been indicted on 3 counts of aggravated trafficking and 3 counts of aggravated possession of methamphetamine. Mr. Taylor's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. This is a final pretrial. I believe we have a trial date set for April the 7th. Now, I believe that discovery was filed. There's no, Mr. Kirk, did you file a compliance with discovery?
I did, Your Honor.
Okay. Well, we pulled these files last week, so we, actually I see over here there's a red jacket. I see them. Yeah, okay. And then it looks like the state filed an additional discovery this morning with a lab report on it. And you received that?
I did receive that. Yes, my client's not yet aware of it, but I will take that out to him.
All right. And I don't see any pretrial motions filed, or did you file any?
I did not. I did not see any warrant for any, so I did not file any.
All right. Now, what's the status of the case then in terms, I know we have a trial set on the April 7th, so that's actually inside the 14-day window, but I believe that this was the best we could do on the scheduling date. So what's the situation here with this case, counsel?
It's protected.
I have made my client aware of his plea offer. We did actually negotiate on that. I have made him aware of the 14-day rule. Also, the form to basically I forget what the technical term for it is, but basically the plea refusal form, gone over that with him as well. He does not wish to sign that form, but has not necessarily stated he wants a jury trial either. He did want me to go back to the state with some additional things, which I did, and they declined to change the offer. So at this point in time, I'm not sure what he wants to do. He's never given me a clear answer.
So, Mr. Taylor, is it, are you rejecting the plea offer the state made and electing to go to trial? Is that your decision?
The process, this process here, this pretrial hearing, I mean, I got motions I'd like to file.
Well, you're not representing yourself. You have an attorney. And so,
I know that.
Wait a minute, just wait a minute. I'm going to address this. And under the rule, motions, if you have an attorney, only your attorney can file a motion. So if you prepare something that you want to file, I have ordered our clerk's office not to accept those. They will not accept them because you are not representing yourself. The only way you can file a motion is if you represent yourself, in which case that would be a huge mistake, and you haven't asked for that, and there's be quiet, don't interrupt me when I'm speaking. I'll give you the chance to talk. You just be patient, listen, okay? One of your problems may be that you want to speak instead of listen, and that's a big mistake too. So, getting back to my point is that there's not what's called a hybrid representation system in Ohio, and that's a criminal case. The defendants can't file their own motions. Now, your attorney's indicated that he has reviewed these with you and didn't find anything that had any legal merit, arguable merit that he could file. And under the rules of law, attorneys aren't permitted to file frivolous motions just because their clients think they should. They're the attorneys. They're the ones that know the law. They're the ones that know the rules of professional conduct. They're the ones that are bound by it, not a defendant who wants to file any kind of number of motions based probably on what you've seen on TV or in the movies, which is, again, a real big mistake to believe that kind of crap. So that's where we're at. Now, going back to my question, are you rejecting the plea offer? Yes? Okay, then we will have a trial on April the 7th. All right, so does the state expect this to take more than 1 day?
No, the state expects this to be finished in 1 day.
Okay. And you agree with that, Mr. Kirk?
I would agree with that, and I would note just for the record, I've been given no names, addresses, phone numbers of any witnesses, so I don't think we'll have very many, if no witnesses at all.
Well, if there's going to be any witnesses, Mr. Taylor, you have to give those to your attorney so that he can file and respond. Those were due by today, so if you've got them, get it to him right away so he can give them to the state. I'll give you till tomorrow to do that. Now, anything else that we need to discuss in this case?
Yeah, I'm gonna ask to have my attorney removed, and I got grounds here. I asked him to file a few motions which are legitimate. I mean, this ain't from TV, this is from going through the law book and studying day in and day out. Everything I got the case numbers, case laws, I got.
Motion, what kind of motions are you talking about, Mr. Taylor?
But one is a motion to suppress. One is, and I got one here, it's a motion.
Motion to suppress, but this is I believe this is a undercover buy situation, isn't it?
It is 3 buys.
Okay, so I don't know what kind of motion to suppress would be appropriate. What do you think could be suppressed?
It'd be,
Well, if you know so much about the law, you should be able to answer that question. I've got an attorney here who knows the law and tells me there's no basis. And now I've got you telling me there is, and I ask you what it is, and you can't tell me.
This sounds like an old TV show, but he's definitely letting him have it.
I asked him to file his motion, and
I know that. I'm saying is, what is it you think should be suppressed and why? What's the legal basis for it that you, being a non-lawyer, has come up with that an accomplished lawyer has not?
got from my paperwork here. Trying to be organized here at the same time.
So you have an answer. What is it you would seek to suppress?
I don't know.
Pardon me?
I don't know.
You don't know? Okay. Anything else you want to bring up?
I'd like to have my attorney removed from the case and have another one, please.
Wait a minute. I'm having trouble understanding you. I can hear you.
I'd like to remove my attorney and get another one.
Okay, well, you have until April 7th to get yourself a new attorney. If you want to get a new attorney, you can do that. You'll have to hire them because you didn't hire Mr. Kirk. You didn't have the money to hire an attorney, so I appointed him for you. So, he's your attorney unless you get a new attorney. But if you do, they need to be ready to go to trial on April the 7th.
I can't get another court-appointed attorney. I can't afford an attorney.
No, you have a court-appointed attorney. I've given you a court-appointed attorney.
But he's not representing me.
Yeah, he is. He's representing you, and he's had conversations with you and discussions. You don't like what he's telling you. I get that. If I were in your position, unless they were telling me you're going to walk free and the state's going to give you a written apology and $1 million, I wouldn't be happy either. But, he's not going to do that. So, unless you can tell me why he is not, he shouldn't be your attorney, and you've given me no reason on the fact that you don't like what he's saying, and he won't file motions that aren't proper, which is no attorney would file. So getting you a new attorney would not mean anything because a new attorney wouldn't be able to file frivolous motions either.
Don't know the law, filing frivolous motions, and firing an attorney? That sounds sovereign to me.
And if I gave you any attorney who knows what they're doing, they're not going to do anything different than Mr. Kirk is. Mr. Kirk's been doing this a long time. Now, anything else you want to bring up?
Yes, I have grounds.
I asked you what your grounds were, and you didn't tell me anything. You said you didn't know on suppression.
I'm trying to be respectful. Wait till you're done talking.
I'm sorry, what?
I'm trying to be respectful. Wait till you're done talking. You got only once for interruption.
Okay. I asked you to answer my question, and you didn't when I asked you what your grounds were. Now, I'm not going to give you another attorney. If you want to get a new attorney, that's up to you. You feel free to do that. You'll have to hire that attorney. But I don't know who told you that you're entitled to get more than one attorney because the court has appointed you an attorney. Mr. Kirk is qualified and competent and experienced, and knows way more than you'll ever know about the law. So just because you've been in court a few times doesn't mean you know anything about the law. Just because you got a book you can read doesn't mean you know anything about the law. I could read a book on brain surgery, but that wouldn't make me a brain surgeon. You can read a book on the law, and it doesn't make you a lawyer. Now, any other things you want to bring up, Mr. Taylor?
Represent myself.
Well, that would be the biggest mistake you've ever made in your entire life. Based upon what you've been telling me, I don't think there's any way in the world you could represent yourself. Pardon me?
I haven't been able to tell you nothing.
I can't understand your mumbling.
I haven't been able to tell you anything.
Well, you're not the attorney. You know, you're on trial. You don't get to participate in your defense because that's what an attorney is for. That's why you have one.
But am I allowed to have a fair and just defense?
Oh, absolutely, and then that's what you're going to get. We'll have a fair trial. We'll have a jury, and we'll have a trial.
I don't have all my discovery. I'm missing 12 things that I'm undiscovered. I'm begging for.
Well, he's got the discovery. Let me explain here, Mr. Taylor. I met with your attorney and the prosecutors before this hearing, and he kind of outlined to me some of the things you're talking about. As I understand it, you have everything of any importance. I think he said you had mentioned that you didn't have a copy of the resume of the BCI analyst or something, which is minor. It doesn't mean much. He can get that to you. He will get that to you. But the other things that you want, I mean, my understanding, he's given you more than what most defendants get in these kind of cases, because usually there's a counsel-only discovery restriction. But since the identity of the CI is known, apparently they have let you watch the videos, right? You've watched the videos of what they say are the buys, right? And then you've gotten copies of everything that he has, pretty much. Is that correct, Mr. Kirk?
That is correct, yes.
All right, so I don't know what you're talking about when you say you don't have discovery, because you've got everything that he's got. And that's it. Discovery is what he's giving you what he has.
My discoveries don't even have counsel. I've only stamped on them.
It doesn't have to have a stamp on it. It's done by email.
And at the same time, I get a piece. I get a piece 1 week. I get a piece 2 weeks later, and I get a piece Monday.
All right. Well, good. It gives you something to do. So what? We still got 10 or 12 days to try. I mean, but again, you're not going to be the one that's going to be questioning the witnesses and presenting evidence and making arguments. That's what your attorney does. Pardon me?
Well, I'm afraid of.
I would be afraid too if I were on trial, but that's not why we're here. This is a final pretrial, and we're ready to go to trial. The court, we're going to send out our jury notices today. The state's ready to go, and you're going to be ready to go unless you get a new attorney. And again, you're not going to get it. I mean, maybe you can find somebody to be willing to take the case and go to trial on the 7th. But that's going to be on you. If you want another attorney, you can get one. But all this stuff you're telling me doesn't amount to a hill of beans, as my dad would say.
I represent myself.
Pardon me?
I represent myself.
Well, if you want to do that, how are you going to do that? What do you know about the law?
I don't know that much about the law.
And so you want to go to trial not knowing much about the law against a prosecutor that does know the law?
I think my percentages would be higher, yes.
Pardon me?
I think I would have, my percentages would be higher, yes.
Well, I can't understand what he's saying.
Yeah.
He said his percentage would be higher. His percentage of winning would be higher if he.
Oh yeah, what do you think that would be?
I don't know.
Well, give me the odds. I'll take that bet. Because you're absolutely 100% wrong. Everything you're saying here is exposing the stupidity of your position.
He definitely said that nicely.
And for me to allow you to represent yourself would be guaranteeing you a conviction. You'd be convicted of everything. You don't know what you're talking about. Have you ever picked? Do you know what the word voir dire means? Okay. Do you know what the separation of witnesses is?
That's one of my motions to seven.
Well, we don't get separation of witnesses. I ask you.
Yes, yes.
What is okay? So what is it?
Fine.
Huh?
motion I asked him to file.
Okay, well, that is filed at the time of the trial. When we start the trial, that's an oral motion. What kind of a motion did you want him to file?
You have to give me time to get it.
No, you're the one that claims to know more than he does. You should have been prepared to tell me. If you've got all these arguments, don't tell me you got to sit there and try to figure this out, because we're not going to sit here all afternoon. You tell me what it is you wanted him to file. You just told me you wanted him to file something. Tell me what it is you wanted him to file. Don't tell me you got to go look for it.
I'm pretty organized here.
Well, why can't you answer the question then?
Because I can't tell you without.
Okay, well, look at it. You should be able to find it. I'll give you 15 seconds. Find it.
File a motion for the rest of my discovery.
There is no other discovery to file, to get. You cannot. Pardon me?
I got a list here.
What?
I think he's basing his list off of other
No,
people
I'm
in the
not.
jail, because he thinks there's a set number. Sir, he thinks
Listen, be quiet. Let me hear what Mr. Kirk's saying. Go ahead.
He thinks there's a set number of discovery items. I've told him that is a myth. Some people may have 14. Some people may have 2. And I've explained that to him. However, he does not trust my advice on that. I do not believe he's missing anything other than there is a lab report that was just filed that I will be taking out to him. But he thinks there's some sort of mythical set number of items.
Okay.
Judge, I can probably shed some light on this as well.
Go ahead. I would like to.
Some defendants believe that they should have copies of the buy money, for example. In this particular defendant's case, those are actually pictures that were on the digital evidence that he would not have access to out there because he's in jail.
Right, I understand.
There are several things that are digital evidence that he physically cannot have access to because he's in jail.
Okay. Well, your attorney has those, and he's shown them to you, as I understand it, right?
Yes, oh yeah, he showed me the digital stuff, but he has showed me, yes, you're right. But also, if they're going to have BCI experts on the stand, and we get a chance to cross-examine them, shouldn't I have their qualifications and all that for cross-examination? Also,
Cross-examination would be based upon their report.
Also, the submission report to the BCI lab, I don't have, and I don't have the physical evidence or the witness. I got the witness list. I don't have the CI's felony report. I don't have the forfeitures. I don't have disclosure of all evidence and everything from them.
Well, your attorney has it, and he has it, and he's discussed it with you. You don't have to have all that with you in jail. I don't know that you'd have room for it. So,
That doesn't exist.
Pardon me?
A lot of this that he's talking, so he just said he doesn't have a list of the forfeitures. There are no forfeitures in this case.
Oh,
he
well,
has
there would
the
be, yeah.
CI's. He has the CI's criminal history. He just doesn't know how to read the discovery. We provide the CI's.
Okay. So-
DCA criminal he doesn't understand what he's reading.
Right? Correct? This right here is a signed paper that's the end of my particulars. That right there, if my daughter needed a permission slip to go to school, I can put this on it. Nothing there says that goes to a bill of particulars. There's no date, no stamp, no nothing on my bill of particulars.
All right, well, I don't really, it really doesn't matter. It's immaterial. You have copies of what is filed, and that's what's important.
I can answer this too.
All right, wait a minute.
I can answer this too. We don't file a bill of particulars in court because it names so much protected information.
Right.
We file a notice of filing. The
Right.
bill of particulars doesn't get stamped or anything like that. It's secret.
Tell that to the solvent community because they always looking for it.
I understand, but it still has to have some more, because it can be reproduced. Everything I got can be.
Okay, well, again, you're operating from a complete ignorance of what's going on here. As she indicated, the bill of particulars does not have to be filed with a file stamp in the public file. And in fact, oftentimes it's not, because it names people that are to remain confidential. And in some cases, we've had a situation where the paper picks it up and prints it all before the trial, and then that person, all that information is out there that could potentially prejudice the defendant. And so your complaint about it not being file stamped, it means nothing. That is a big fat zero that means nothing. You have a copy of it, and that's all you need.
Criminal Rule 16C says that it has to be prominently stamped, counsel eyes only. And everything they gave me.
Well, it's not stamped cancel eyes only. You've got everything in this case. Now, I'm not going to argue with you anymore. All right? The bottom line is, what you're saying is all without any legal merit whatsoever, because you've read a book and you think these things say this and that, and they don't. And you're not entitled to stuff that doesn't exist. You don't have to have stuff that doesn't have to be file stamped, and nothing that you've told me means has any legal significance at all.
The question is he sovereign or not? Put it in the comments.
It seems to me that what you ought to be doing is focus on the allegations in this case and the evidence that you do have in this case, which is apparently some videos or audios and witness statements and people who are going to testify. That's the stuff you need to be focusing on, not on a whole bunch of stuff that you think you should get that either one doesn't exist, or two is you have it and you don't understand it, and that's your fault. And that's just, again, the fact that you don't know what you're talking about. That means
I told you everything.
Pardon me?
I brought so much to my lawyer, and he has dismissed and excused everything. I got this form smoking crack in the video, but he dismisses it, justifies it. It says I'm smoking a pipe, and nowhere in the video I'm smoking a pipe, but he dismisses it and justifies it.
Well, it'll be in the trial. I mean, if whatever the videos show, they show. I don't know what's on there. This isn't about that. We're not going to argue about that. Whatever the evidence shows will be what is going to be introduced at trial if we're going to have a trial. And it sounds like that's what you want. So if you want to have a trial, that is completely fine. We're going to go ahead and send out a jury notice here this afternoon, and we'll summons in the jurors, and we will see you on April the 7th. Again, if you want to represent yourself, again, I would tell you that would be a big mistake. But if you want to file that motion, I will have a hearing on it and give you the opportunity. But I can tell you that you will absolutely have no chance in the world at a trial based upon your performance here today. Because just because you represent yourself doesn't mean you get to bring up everything that your attorney says you can't. Because if he says you can't do it, and he's right, which I'm guessing that he is, because he's been around the block a few times and tried cases in his court, then you're not going to be able to bring it up. And so when you're being upset with him not bringing up stuff you want him to, when he tells you you can't, it's not admissible, that's going to be the ruling of the court. And most likely what will happen is you're going to come in here thinking you can do this and that, and you can't, and I won't let you. You'll end up hardly having anything to say on your own behalf. You're not the first person I've dealt with that's represented themselves, or wants to represent themselves. And if you want to do that, you can file a motion. There's a hearing I'll have to go through and ask you a whole bunch of questions that will point out, what a big mistake that is. You'll still have to have a legal advisor to stand by to answer questions for you at the trial. They won't be able to participate, and we won't start the trial you representing yourself and then coming to your senses and finally realizing you've made a big mistake and then say, okay, Mr. Kirk, I'm in over my head, take over. That's not the way it works. Once you start it, you're going to finish it. And so, again, under the law, unfortunately, the court is not permitted to protect the biggest right that a defendant ought to have, which is the right not to be stupid. And unfortunately, you do have the right to be stupid, and you can exercise that at any time. And if you exercise that by representing yourself, that will be the biggest mistake you've ever made. I'm just telling you that. I can tell right now that you're not going to be able to effectively represent yourself. But if you want to, once we go, just be quiet, I'm explaining. If you want to file that motion, that's one motion I'll permit you to file on your own. We'll have a hearing on that, and we'll go through all those requirements I'm going to have to do. I'm done with you now because I've got other cases I need to move on to. This is a pre-trial, not a trial, and I'll make that ruling. And so if you want to do that, I'll have a hearing on that, maybe Monday, and that'll give, and we'll see what's going to happen. Again, I'm telling you, do not try to represent yourself. And because, when you said your odds will be better, they'll be infinitesimally worse. They'll be so much, so bad that you can't even imagine it. And again, these cases, in cases like this where, you need to focus on what the evidence is as opposed to what you think your attorney is or isn't doing. That's the issue. Look at the evidence that you do have. What is the evidence against you that the state says they're going to present? And then make your decision based upon that. And as far as asking for stuff that's not out there, or stuff that you can't have in jail because it's digital, and your attorney has shown you those things, you have everything that the state has. There's nothing more they can give you. And so, you could file 135,000 motions asking for more discovery. If there's nothing more to give you, they're not going to be granted, So, what you're asking for is stuff that you apparently think you know about that you don't. And again, I don't know where you come up with these 14 items of discovery, but to the extent that you're getting advice from people that are in jail, think about, how smart they are if they're where you are.
I'm saying I'm getting my ideas from everywhere else. Every idea I'm getting is coming from the Criminal Handbook 2018, and everything comes out of it that I've got.
You've got everything you're supposed to get. That means the criminal law book doesn't create things. It just tells you what you're entitled to. The state has provided all that. Your attorney has got it. He has shown you everything other than this last lab report, which just came in, and he's going to give that to you. He just got it today. So, you have it. There's nothing that you are entitled to have or can have that you don't have. So, I don't know. I don't know what else to say. So, all right. Now, we're done. Anything else from counsel?
No, Your Honor.
All right.
No, you're right.
All right. Thank you.
Come see me soon.
I will be out to see you, yes.
Okay, now we're done with the first hearing. So you up to speed on that. Now let's go into the second hearing to see what's going to happen on his last disposition. I'm sure you're wondering what this is. Well, we're going to find out. Let's go.
All right, this is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. You're Brian Keith Taylor appearing there from the jail. All right, and if you would keep your voice up so we can get that. I just barely heard you, but make sure the recording gets you. This is a hearing set at the request of the parties for a plea. Mr. Taylor, it's being conducted by Zoom. Mr. Taylor's appearing from the jail. His attorney is Dennis Kirk, appearing from his office. Appearing from the prosecutor's office is Assistant Prosecutor King. Now, before I go into the plea form, Mr. Kirk, are you and Mr. Taylor both waiving his actual appearance in the courtroom and agreeing that this matter can be conducted remotely by Zoom?
Yes, Your Honor.
And you're okay with that, Mr. Taylor?
Yes.
All right. All right. Well, since you're not seated in the courtroom next to him, if at any time during this hearing you need to talk to him or ask him any question, you just let me know, and then I can put you and him into a breakout room. It'll be just the two of you on the screen. The rest of us won't be able to see you or hear you, and while you're consulting with your attorney, the deputy would step out so that your consultation is totally private, okay?
Sir.
All right.
Yes, sir.
All right. Thank you. That's good. I heard you well there. All right. Now, Mr. Taylor, I have a plea of guilty form here that says that you're going to plead guilty to counts 1 and 5. And this is a 5-page document in total. I'm going to hold up to the camera the first page of the agreement, which has the caption of your case with your name, excuse me, and case number, plea of guilty. And I'll ask you if you recognize that document.
Yes, Your Honor.
On page 4, the last sentence at the bottom reads, "I enter this plea voluntarily," and then immediately below that appears signature Brian K. Taylor. And I'll hold that up to the screen and, whoops, I'm sorry. And is that your signature there?
Yes, Your Honor, yes.
All right. And I assume you just signed this morning.
It was yesterday.
Oh, you signed it yesterday? Oh, okay. All right. I just heard about it this morning, and I thought it was just, all right. So, when you signed this, did you understand that it was an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes, Your Honor.
And before you signed it, did you go over this and have Mr. Kirk explain things to you and answer any questions?
Yes, Your Honor.
Okay. And I know that we had a really lengthy pre-trial yesterday, and there was a lot of discussion. But since then, after that hearing, you decided that this is what you want to do?
I believe it was the wise thing to do.
That's well put. I would agree with you. Nobody wants to plead guilty, but it's the wise thing to do. Sometimes it's a wise thing to do under the circumstances. So is that the decision you've made?
Yes, Your Honor.
All right. And you're doing this voluntarily again under the circumstances that you find yourself in?
Yes, Your Honor.
All right. And do you feel that you were pressured or forced to do this against your will, other than, again, the situation of the case and the evidence and the proceedings against you?
Yes, Your Honor.
All right. Now, the agreement states that you're going to plead guilty to count 1, aggravated trafficking of methamphetamine under Section 2925.03A1, a third-degree felony, and aggravated trafficking of methamphetamine under count 5, under the same statute, a second-degree felony. Now, it further states on page 1 that you understand that the penalty for count 1 could be 9 to 36 months, and there's certain levels provided by law. It goes 9, 12, and then 18, and then every 6 months level up to 36 months as a maximum. There's a fine of $10,000, mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. Now, it further states that you understand that the sentence on count 5 is a second-degree felony, and that sentence is a mandatory term of between 2 and 8 years as set by the judge, a fine of $15,000, fine of $7,500 mandatory, 6 months, 5 year suspension, and again, the 2 to 8 years is a minimum mandatory sentence that is set by the judge. Do you understand that?
Yes, Your Honor.
And if you're convicted of both of these offenses and sentenced to prison, the terms could be ordered to be served consecutively to one another. And so 36 months is equivalent to 3 years on count 1. 8 years is the maximum on count 2. So that'd be a potential mandatory, or not mandatory, but sentence of 11 years. Do you understand that?
Yes, Your Honor.
Now, other than these 2 charges, Mr. Taylor, are you facing any felony charges anywhere else?
No, Your Honor.
And are you currently on probation, parole, community control, or post-release control for a felony?
No, Your Honor.
Now, on the 5th count, I indicated just a moment ago that under the law, the sentence for that is 2 to 8 years as imposed by the judge. It's a mandatory sentence, so there's no option for me to do anything on that other than to sentence you to prison. There can't be any community control or probation. There cannot be a judicial release or any reduction by the court. You get good time credit, or you get jail time credit, and then some credit may be able to be earned depending upon the circumstances at the institution. But that is the sentence. So I'm going to use the worst case scenario since that's what you need to be aware of. So, under the law, if I sentenced you to 8 years for conviction on count 5, you would have to serve that period of time less any credit that you have. as of the time you get to the prison. And so that means that you would presume that would be your release date. Now, under what's called the Reagan-Tokes Law, which is discussed on pages 1 and over to top of page 3 of your agreement, the Department of Corrections can ask for that to be extended. And what they do is they have to have a hearing in front of a hearing officer, and they have to make prove specific determinations about your conduct while you were in prison or up to that point, their opinion of your rehabilitation, the threats you may pose to society, whether or not you were under any restrictive housing while you were in the institution, and whether whatever your security classification was. And if those certain things are found by the hearing officer, then the department can rebutted that presumption, and that means that it could then extend your period of incarceration for an additional period. And they could do that more than one time. They could do that several times, up to a maximum of half of the prison term. So if the 8 years was the sentence that you received, they could then extend that after they go through that hearing process and make those specific determinations for a total of up to 4 years. It might be, if they did it once, it could be 6 months or a year, could be 2 years, could be 4 years, but could never be more than 4 years total, no matter how many extensions they make. And then at that time, you would be subject to being released on that sentence. Now, do you understand that?
Yes, sir.
All right. And again, you understand that with regard to count 5, there can be no probation or community control, so there will have to be that mandatory prison term. That's the minimum, and the maximum with the additional 4 years. You understand that? Okay. So to complete the explanation of the total maximum then, if you received a total of 8 years on count 5 mandatory, and the 36 months on count 1, that would be 11 years. And then with regard to count 5, that can be extended by an additional 4 years. And so that means that that could be a maximum of 12 years on count 5 and 3 years on count 1. So that would make a total of 15 years maximum. Do you understand that?
Yes, sir.
All right. Now, count 1 of the indictment alleges that on or about March 26, 2024 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount that equals or exceeds bulk amount but less than 5 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code, which is a third-degree felony with the penalties I just described. Count 5 alleges that on or about April 1, 2024 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount that equals or exceeds 5 times the bulk amount but less than 50 times the bulk amount, in violation of 2925.03A1, which is the second-degree felony with a mandatory prison term that I've just explained to you, and the financial penalties, and both of them do carry a potential license suspension of 6 months to 5 years. Now, Mr. Taylor, do you understand what it is you've been charged with in each of those 2 counts, what the state said you did, when, where, and how they alleged that you did them?
Yes, sir.
And you've discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney.
Yes, sir.
And I know we had quite a discussion yesterday about the matter and some of the things that you were thinking. But now that you've had time to reflect on everything and consult with him after that occurred, Are you satisfied with his advice and competence in this matter?
Yes, Your Honor.
All right. Now, are you under the influence of any types of drugs or alcohol at this time?
Caffeine?
Me too. If it weren't for caffeine, I probably wouldn't be here. I had trouble sleeping last night. So,
No, Your Honor.
yeah. Okay. Has anyone threatened you to make you plead guilty?
No, Your Honor.
All right. Now, on page 3, there are several lines printed in bold and underlined, and they read as follows. Defendant shall enter a plea of guilty to count 1 and count 5. State will dismiss remaining counts. State and defense jointly recommend 24 months incarceration on count 1, consecutive to 4 years, mandatory incarceration on count 5. And I'll note that the 4 is written in ink, so apparently there was another number that was whited out and inserted, and that's the agreement of the parties is 4.
Yes, Your Honor.
Yes, Your Honor. All right. And it further says the defendant agrees to cooperate fully with the task force and agrees to repay by money to the task force in the amount of $520. Is that your understanding of the agreement, Mr. Taylor?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, Mr. Taylor, the matter of sentence is up to the judge, not the parties. And so, even though there's a agreed recommendation between you and the state that you get a total of 4 years mandatory on count 5, which means you could be up to an additional 2 or 6 years if they extended you, as we discussed in the earlier, and plus 24 months on count 1. The court is not bound by that recommendation. And so if you plead guilty, once the court's heard all the information submitted, if I should decide that's not the correct sentence, I could sentence you to any sentence between 2 and 8 years that I think is appropriate, which would be subject to being increased by up to 1/2 by the Department of Corrections, as I explained to you earlier. You understand that?
Yes, Your Honor.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, Your Honor.
Right now, you have certain constitutional rights I must understand, or I must explain to you and have you understand before I can accept a plea of guilty from you. First of all, you have a right to counsel, and since you were unable to employ your own counsel, the court appointed Mr. Kirk to represent you. Now, Mr. Kirk's appointment isn't to try to simply get a workout of the case and get a deal. It's his responsibility and appointment to provide any defense that is available to you under the law that you would like him to provide. So if you don't want to do this, if you want to fight these charges and defend against them, then he will continue to represent you and advocate on your behalf against the charges, including a trial, if that is what you wanted. Do you understand that?
Yes, Your Honor.
Now, Mr. Taylor, under the Constitution and the laws of this state, you have the right to have a jury trial on these charges, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After 12 of those folks are selected, the evidence will be presented, and then they'd be instructed on the law by the judge. The jury would then decide by unanimous verdict, meaning all 12 would have to agree on a verdict on each of the 2 counts. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning that instead of a jury, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, Your Honor.
Under the Constitution, Mr. Taylor, you have the right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in open court in front of you, your attorney, and anyone else is present. After the prosecutor is done asking questions of those witnesses, then your attorney can ask questions. That's called cross-examination. The purpose of that is to try to bring out evidence that might help your side of the case. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, Mr. Taylor, you have the right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court will issue a court order called a subpoena. And that forces those people to come to court and be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, Your Honor.
Under the Constitution, you have a privilege against self-incrimination on these matters, Mr. Taylor, which means that you cannot be forced to give evidence or to testify against yourself at any time in these proceedings. So no one could ever make you testify. The prosecutor can't, the judge can't. It's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by anyone at any time in the proceedings. And in fact, no one is ever permitted to even discuss that during the case, with one exception. If there's a jury trial and you do not testify, then the judge does instruct the jury that because that is your constitutional right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you're presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each offense. What that means is that the burden of proof isn't on you to try to prove that you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at trial on your own behalf. You may, but you're not required to. But whether you present evidence or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of each offense by proof beyond a reasonable doubt, which is the highest burden of proof that is known under the law. Do you understand that?
Yes, Your Honor.
All right, now originally you entered a plea of not guilty to these charges, Mr. Taylor. The plea of not guilty denied the allegation in each of the counts in the indictment, denied you committed any crime, and it exercised or invoked all the rights I have just described for you this morning. You change your plea on counts 1 and 5 from not guilty to guilty. That is the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment in count 1 and 5, admits that there are crimes, that you committed those crimes. And that plea would waive or give up all the rights I've described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea may be. But with that exception, a plea of guilty would waive or give up your right to a jury or court trial. It would waive or give up your right to confront witnesses against you and to cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination because you're saying you're guilty, that's what you find you're guilty. It waives or gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had for any alleged violations of your rights that you think may have occurred up until this point in the case. Now, if I should sentence you to the maximum sentence on either charge, or under other certain limited circumstances you could file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Oh, no, you said I have no right to appeal at all?
If you plead guilty, you do not have the right to file an appeal on any claims of violations of your rights you feel may have occurred up until this point in the case. So, I know you brought up all these things yesterday, which I indicated to you didn't have any merit, but if you plead guilty, then you can't appeal those.
Understand?
All right. So, you understand that then?
Yes, Your Honor.
All right. Now, are you a U.S. citizen?
Yes.
Now, do you have any questions about the charges or the possible penalty?
No, sir.
You understand them?
Yes.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yes, Your Honor.
Have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand those?
Yes.
You have any questions about the plea of guilty or what the consequences of that will be if you enter that plea?
No, Your Honor.
And again, you understand the plea of guilty waives or gives up your right to file an appeal on any alleged violations you think have occurred in this case.
Yes, Your Honor.
All right. Is there anything you would like to speak with Mr. Kirk about, or any questions you would like to ask him before we continue?
No, Your Honor.
Now, do you have any questions about anything that I've talked about here this morning, or anything that's going on here this morning?
No, Your Honor.
Then is it your decision that you're going to withdraw your plea to count 1 and 5 and enter pleas of guilty pursuant to the terms of this plea agreement?
Yes, Your Honor.
And you're doing this voluntarily given the circumstances you find yourself in today?
Yes, Your Honor.
All right. Then as to the charge in count 1, that alleges that on or about March 26, 2024 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount that equals or exceeds bulk amount but is less than 5 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code, charge of aggravated trafficking of methamphetamine, a third-degree felony carrying a possible prison term between 9 and 36 months in increments provided by law, a fine of up to $10,000, a mandatory fine of $5,000, a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
As to count 5, which alleges that on or about April 1, 2024 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount that equals or exceeds 5 times bulk amount, but less than 50 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code, the charge of aggravated trafficking of methamphetamine, a second-degree felony, carrying a mandatory prison term set by the judge of between 2 and 8 years, with a possibility of that being extended under the Reagan-Tokes law that I explained in your plea agreement by up to 1/2, a fine of $15,000, a mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds that on this day in open court, the defendant was advised of all of his constitutional rights and made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal Rule 11. The pleas to count 1 and 5 of guilty are accepted and ordered filed with the court. Defendants found guilty of counts 1 and counts 5. The remaining counts are dismissed. Now, since there is a mandatory prison term required on count 2, and there's a joint recommendation on the sentencing, and I have looked at the discovery and note Mr. Taylor does have previous felony convictions and sentences of imprisonment. The court is not going to do a pre-sentence report. So I'm going to go ahead and proceed with sentencing immediately. Anything from the state regarding sentencing?
Only what is contained in the plea agreement, Your Honor.
Mr. Kirk?
Thank you, Your Honor. Would ask the court to follow the plea agreement. As to the mandatory fines, I do not believe my client's financial situation has changed since he's become incarcerated, so would ask the court to waive the mandatory fines given that situation and follow the plea agreement. Thank you.
All right, Mr. Taylor, is there anything you would like to say?
No, sir.
All right.
No, Kirk, said facts.
You're welcome.
Okay. All right. All right. Well, Mr. Taylor, I know as I noted, you've got quite a lengthy, well, not the worst I've ever seen, but there's a substantial criminal history. I don't know exactly how old you are, but at some point in your life you need to start thinking about leading life in a different manner than you have been. So, the court is going to follow the plea recommendation because I know it's been a difficult process and sometimes contentious, but this agreement appears to the court to be a reasonable and fair resolution as recommended by the parties. So, it is the court that you be and are hereby sentenced on count 1 to a term of 24 months incarceration, and on count 5 to the mandatory period of 4 years. and those sentences are to be served consecutively to one another. The court finds that, first of all, that's a joint recommended sentence. Secondly, the offenses are committed as part of one or more series of conduct, and that one single sentence would not adequately reflect the seriousness of the crimes, and the sentence is being imposed, which is a mid-range sentence on both counts, actually, pretty much in the middle. That sentence is not disproportionate to the harm that's caused. The court will also note that the defendant has been previously convicted, looks like most recently in this court, of illegal assembly in 2013. He had a B&E and theft in Madison County in 2006, and illegal assembly in this court in 2002. Looks like B&Es in Highland County in 1986, and B&E and defrauded an innkeeper. Didn't know that was an offense in Ohio, but it's what it says, in 1985. Pardon me?
With the prosecutor.
Yeah, I'm sure I was. I don't remember it, but I don't know what a defrauding an innkeeper is. Probably was a misdemeanor or something. I don't recall that. But anyway, based on that, the criminal history is such that it demonstrates that a consecutive sentence is necessary to protect the public from future crimes of the defendant. Now, according to the Sheriff's Office, you were arrested on January 28th. Is that correct, Mr. Taylor?
Correct.
All right. So that would give you, as of today, 58 days of jail time credit. Now, with regard to count 2, as I explained when we went over the plea agreement, that sentence of 4 years is mandatory, and less jail time credit at all has to be served. And that is the date then, as to that charge, it would be pursued that you would be released. You'd still be required to serve the other sentence, but that would be the release date on that offense. As I explained earlier, the Department of Rehabilitation can overcome that presumption if they go through a hearing and there are specific determinations that are made about your conduct while you were confined, your rehabilitation, any threat you may pose to society, any restricted housing that you were required to be in while incarcerated, and findings regarding the seriousness of your security classification. And if those determinations are made and rebut the presumption that you should be released after your 4-year sentence, then the department may continue you in incarceration after that date for up to 2 years, which would be half of the prison term of 4 years that's imposed for that offense, in whatever increments they would decide. They could do it all at once, or they could do it in 2 or 3 or 4 increments, however they wanted to do it, for whatever determined periods of time they think are appropriate based upon the findings. And so after that, if those findings are made and that sentence is extended, once the extension is served, and again, the maximum of that could be 2 years, then at that time you'd be released. Now, under the law, it's mandatory that you be placed upon post-release control in this matter as to count 2 once you complete the sentence imposed by the court. It's optional in count 1, but I'm sorry, count 5. Count 5 is mandatory, not count 2. Count 2 is dismissed. But count 1 is optional. But in any event, it doesn't matter because it's going to be mandatory in count 5 that you be under supervision for at least 18 months up to a maximum of 3 years. And that will be determined by the Adult Parole Authority. They will set the conditions, and you'll be supervised by a parole officer. If during that period of time that the APA determines that you have not complied with those conditions, then they could return you to prison as a sanction to make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. However, if you are convicted of a new felony while under post-release control supervision and are sentenced to prison for that offense, upon completion of that sentence, it is possible, or it is up to the court to determine whether you should receive an additional sentence, and that would be possible 1 year or whatever time is left on that period of post-release control, whichever is greater. And if the judge does decide to impose that, that has to be served consecutively to the sentence in this case. Now, you're also ordered to pay the court costs, which judgments, grant, and executions ordered. If you fail to do that, then the clerk of court can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you are released, you could be permitted to do community service in this county and be given credit for each hour you worked in an hourly rate set by the court. And each hour you work would reduce your judgment by that amount until paid in full. You are also ordered to pay restitution to the Highland County Task Force in the amount of $520, and that'll be payable through the Highland County Victim Witness Restitution Escrow Account. That obligation cannot be discharged, is not waived if you serve all of your sentence. It's part of the sentence and will continue until it's paid. And if you were to fail to pay that after you are released from prison, and it was shown that you had the ability to pay it, then you could be subject to being jailed for contempt or through other collection efforts. Now, you've had no financial change since you were arrested on January the 28th, and the court appointed an attorney for you?
No, Your Honor.
All right. Then the court will find that the defendant does not have the ability to pay the mandatory fine at this time, that it's unlikely due to his incarceration that he's going to be able to pay it in the near future, and therefore the court will waive the mandatory fine. I'm also not opposing any driving suspension on the case, on the offenses. All right. Is there anything further from counsel?
No, Your Honor. No, Your Honor.
All right. All right, then you're remanded back to custody, Mr. Taylor. Thank you.
Okay, that's the end of this entire case. Now, first hearing, he come with all that paperwork and saying he's going to do all this stuff. I don't know what changed on the plea. I don't know how they got that arranged, but he wasn't supposed to go to court until April 7th. So somebody made some kind of communication. And even the day before, I didn't know nothing about that. So I luckily caught this. So I'm sure you enjoyed everything. I hope you have a good day, evening, or night, and see you around the next video.